如果现在是开机，就你卡着它在上面。
Hello, sorry, but slightly delayed. Shall I put it a bit higher? Huh? You don't mind? Okay, okay, yes, sir. Put it like this. Okay. How?
Bolehlah sikit-sikit Tan Sri.
Okay. I hope it doesn't fall. All right. I am distributing the press release that is in writing so that whatever I read out, you will not miss any words. Yeah? If some of you do not get it, please let me know. We will get copies distributed to all. Oh no. Mana Tizul? Can somebody go and talk? Go and talk. It's covered. Where's Ola? Ola, you go and talk to the bird. Okay. All right. Okay, all here. Now, there are two matters. One matter is a small one, which I will deal later, which took place this morning with regards to Tan Sri Sharil issue. But that is a smaller matter. But the main matter that I want to inform you, and I think we owe you an obligation to tell you of the development in the case of Datuk Sri Najib's quest to fight for his case and to get released. We have just filed only hours ago, about 1:30, we have just filed a petition to the United Nations. Okay, we have filed this in Geneva by way of digital transmission. We have done it at 1:30. And this is a document in the form of a petition by Datuk Sri Najib personally through us, the council. This is entitled Communication to the Working Group on Arbitrary Detention. We file it at the Office of the High Commissioner for Human Rights, which is addressed in Geneva, and this was done today on 5th January 2023. The title of that complaint will obviously be Datuk Sri Muhammad Najib bin Haji Abdul Razak versus Malaysia. All right, versus Malaysia, because we're taking the country to the United Nations, because we are saying that the country has failed in not giving Datuk Sri Najib the fair trial that he deserves. Now, I want to read the press release first. Datuk Sri Muhammad Najib bin Haji Abdul Razak, the former Prime Minister of Malaysia, today brought a petition before the United Nations Human Rights Council Working Group on Arbitrary Detention, acronym as UNWGAD, to ask for a release or a retrial following an appeal hearing at the federal court, which had serious defects and was contrary to the rules of international justice. He's asking the UNWJAD panel of 5 experts, 5 legal experts on international justice, to rule that the dismissal of his appeal by the federal court a reasonable opportunity to argue his case and denied his lawyers adequate time to prepare it. As you can appreciate, he asked for 2 to 3 months or 3 to 4 months because of the change of lawyers. He was not given that. The court did not allow his defense team even to make submissions in the appeal against his sentence of 12 years imprisonment. In essence, Najib had been sent to jail without the opportunity to defend himself at the federal court. The final few days of the appeal in August amounted to a rushed justice when his lawyers were not allowed the time that was obviously needed to read the many tens of thousands of pages of the appeal papers or to come to grips with the 94 grounds of appeal that his previous lawyers had filed. The previous lawyers meaning Shafi and Co. Then it was his opinion was, and I quote again, an important milestone on my journey to freedom. This was stated by Datuk Sri Anwar Ibrahim himself over his predicament from the first case that he had in the courts in Malaysia. As the beneficiary of a ruling from UNWGAD, Datuk Sri Najib expresses the hope and confidence that the current government will follow the UNWGAD's ruling upon the same being made available in due course. Right? That is the official statement. You have a copy of the written version. I want to just highlight a few things. I can provide you this. This is the actual petition, and it is supported by a bundle of documents which is exhibited. This will be the bundle of documents, bundle of exhibits that will go with this. In fact, all this has been filed today. Now, this, we call it the communication to the working group on arbitrary detention. I just want to highlight a few things. And I think it is important that you know, and you may want to ask me questions after this. Now, you remember the episode at the federal court became not satisfactory as far as we are concerned. In fact, as far as any human rights lawyer worth his salt is concerned, what happened in the federal court is most unsatisfactory. Now, there was a change of solicitors and counsel, no doubt, about 5 weeks before the commencement of the appeal, which was to start sometime in, was it in October? No, August, in August, 15 August, somewhere. Now, the lawyers, the new lawyers have convinced Datuk Sri Najib, and this is because they hold that honest view that with the change of lawyers suddenly, for purposes of getting a second view or prospect of the case, they would be able to get the adjournment because nobody could prepare a case of that massive amount of documents within 5 weeks. There's no way you can even finish reading the documents. Now, so when they appeared, the new lawyers appeared from the first day itself. They have indicated earlier that they were going to ask for adjournment for 3 to 4 months. They were refused. All right, the court refused. Mind you, this is the first time ever an adjournment request was made at the federal court by Datuk Sri Najib. He has never asked for adjournment. And you must know, there are many cases you have appeared in the federal court. Whenever an accused said, I've changed counsel, give me time to look for a new counsel. He never even said that I've got counsel, but my counsel need time to prepare. Even in a situation where he said, I have changed counsel today, give me time, I want to get a new counsel, court has never, and you can take it from me, you can record it, the court has never said no. Okay? Now here is a case where Datuk Sri Najib said, I've engaged new bunch of lawyers 5 weeks ago. There's no way they can prepare and argue this matter. I want an adjournment. The lawyer said they need the adjournment in order to be effectively preparing for the appeal. They were denied this adjournment. All right? That goes squarely against the United Nations guidelines, namely the right to counsel means you must have counsel that is effective. No point having counsel sitting there like what happened in this case. Counsel said, I cannot argue because I have not read. There was no opportunity to read. The federal court ordered the counsel to sit there throughout the session without him contributing a single word. Okay? So to us, this is a fundamental breach of human rights. Now, and this is not just international law on human rights. Our law in the Constitution itself, under Article 5, says, Article 5 on liberty, freedom and liberty, demands that fair trial be also accorded to any accused person. And this has already been subscribed to in view by the federal court in several cases. So our own law says you must give him the right to a counsel, the right to a fair trial. Now, you remember in the federal court, there was a case involving a Yemeni student who was defended in somewhere in Tawau. I became the subsequent counsel, but the lawyer who defended him actually has never defended a single case on drug trafficking. And he was actually dying of cancer. For some reason, I don't know why, he took the case and he didn't complete it. He died midway. And the poor Yemeni student was not defended well. The federal court held that that was not an effective engagement of counsel because the counsel was not effective. Therefore, the right to counsel was deprived. That was a case where actual argument was made, but not effective. It was, in fact, a very shoddy argument. And the federal court said that the right to counsel was deprived. And they ordered a kind of retrial back to the High Court. Second point I want to tell you is this. There was no allegation that Datuk Sri Najib, neither the prosecution nor the court, make any allegation that Datuk Sri Najib attempted to do a ploy to get an adjournment. This was not a ploy to get an adjournment. Nobody has accused him of that. Neither did they accuse the new lawyers. In the context of there being no accusation that this was a we would have argued if we were the counsel, but we were not then, yeah, that the 210 million fine was totally wrong in law because it is not mandatory. But the judge thought it was mandatory. The first judge thought it was mandatory. Court of Appeal just approved it, and the federal court never heard anything and approved it. Then we have We have quoted various provisions of the UDHR, Universal Declaration of Human Rights, that was passed in 1948 when we became part of the United Nations. We adopted UDHR. We are not a member of ICCPR. ICCPR is also part of United Nations, International Covenant for Civil and Political Rights. Although we are not members, ICCPR and UDHR have got almost identical provisions. So when this body, this working group consider the breaches, they will consider both almost concurrently. All right, now, first we say the refusal to adjourn means that the right to counsel of his choice was deprived of him. Second, under Article 14, we are saying the general rule is requiring a fair hearing, like our Article 5. That was also denied to Datuk Seri Najib. Then Article 14, bracket 2, is the presumption of innocence, which is also part of our law. When the federal court took that stance, that I'm not going to adjourn this matter, and it resulted in what was feared most, that they rushed through the proceedings and confirmed the conviction, that presumption of innocence was discarded by the federal court. That is against Article 14, bracket 2. Now, Article 14, bracket 3B for Bravo, denial of adequate time and facilities to prepare the defense is also a serious breach. All right? Now, this part of it, there are many authorities. All these cases that I've quoted to you, the various rights I've quoted to you, there are cases in the United Nations that are reported. One such case is a case called Nasheed versus Maldives. Yeah, opinion number 33 of 2015, where they agreed with this principle. There are many others. You remember the recent president of Brazil, Mr. Lula. Sorry, he's currently the president. Yeah, he got sworn in last week. He was in the prison, convicted for corruption, but there were so many breaches. He filed to the same body, all right? And the United Nations Working Group advised Brazil to release him because there were so much breaches in the right to a fair trial and so on and so on. Almost the same sort of provisions that we have raised here. Brazil initially did not follow the advice, which they shouldn't. They have to follow the advice. But what happened was, as a result of the strong opinion from the United Nations, the court in Brazil reviewed the conviction of Mr. Lula and released him in time for him to stand for election for the president of Brazil. So, if you ask me, is this effective remedy? The answer is yes. Although it is not what they call it binding, but you remember we had Privy Council before. Privy Council before, we had Privy Council in England. It is also advisory. Technically, it is not binding. But no Malaysian government has ever said we are not following it. They always follow it, because if you don't follow it, there are consequences, diplomatic in nature, as well as various other consequences that has got international repercussion to Malaysia. Yeah? Investors will not want to come in and things like that, because you are not complying with human rights. And this is, if the United Nations say you're not complying with the human rights, then it is best that the country follow the advice given by the United Nations. And the last principle is, of course, the last two principles, there is no equality of arms. Equality of arms, they're using the concept of war. If you have this amount of, guns and cannons and whatnot, to be fair, the other side must have similar things. So we are talking about the courts. If the prosecution is given that privilege when they were completely ready, the Datuk Seri Najib lawyers, the new lawyers were not ready, there is no equality of arms, and therefore is a breach of a fair trial proceeding. And the last one, of course, and this was quite shocking, the case in the federal court where they denied the appeal and they confirmed the conviction was merely 2 pages, the judgment. All right, in the High Court, it was 780 pages. In the Court of Appeal, it was about 350 pages. In the federal court, it was 2 pages. You know why? Because they never hear the argument of the merits of the appeal, the merits of the case. So what they did was they did a kind of judicial review. Judicial review is to see whether judges were right or wrong in the way they make assessment. But that's not an appeal. In an appeal in the federal court, you do a rehearing of everything, facts as well as the law. The federal court failed to see the difference. So this is also a fundamental breach. All right, I don't want to bore you too much with the law, but that is a short summary of what we have sent in this document that I've just shown you. Any questions on this matter first?
How soon do you expect the UN working committee to reply to your decision?
Okay, they sit 3 times a year, all right? And we're expecting the first sitting for 2023 to be very soon. And I'm told from a reliable source, they come back from New Year, Christmas holidays only on the 9th. Okay, so they have got it today on the 5th. I'm sure by the time they got it, they will start processing it. The procedure is they will send this entire thing. It is not our duty. They will send it to the government of Malaysia through the diplomatic services, through our Wisma Putra, to be served on the Malaysian government so that the Malaysian government respond to our allegation. All right? And then, if the Malaysian government respond, then they may ask us for further rebuttal, and then they will decide. Very rarely do they invite counsel to appear before them, but it can happen, but very rarely. All right? So to answer you, I think is within a few months they will hear it, and how fast they make the decision, I'm not certain. All right?
Yes. It's going to affect the energy review next week.
Okay. Okay. The 2 things are separate. All right. The review is to invite the domestic tribunal, which is the next quorum of the federal court, to say that the first quorum was totally wrong. They did not abide by the procedure, the constitutional protection. They didn't do all these things. One of the biggest point that we are going to show, apart from you didn't invite us to submit on sentence, is the fact that show me one case in Malaysia since 1957 or earlier where you did not give adjournment when counsel have just been changed. How did you force somebody like Datuk Sri Najib, forget about his status, he can be Awang or Ahmad from the kampung, it doesn't matter. How dare you not give him the right to change his counsel and to be fully prepared? That is something that we address the domestic tribunal, namely the federal court, at the review. Okay, but what we wrote to the United Nations in Geneva is to take it to the international dimension, because there is a breach of international human rights, which is a standard that we subscribe to by being a member of the United Nations. No point being a member of the United Nations if you don't abide by your own membership to the United Nations. This is a standard behavior that is expected of civilized nation. Unless we want to be called another banana republic, that's another story. So if you want to be considered as a game, as a player in the international human rights concept, we have to behave the way the international standard has been prescribed. So that is an international dimension. But assuming on the 19th this matter goes on in the federal court, and assuming we win, we will immediately write to United Nations, the same UN working group, to advise them that this is what happened. This is what has happened. Therefore, the remedy, in short, has been achieved. They may accommodate what is the latest that has happened in their opinion to the Malaysian government. So it is not inconsistent. Yeah, same thing with Lula, same thing with Nasheed. All this we did. There are many Arab countries that have also resorted to United Nations with regards to individual rights, and they have won. All right? Yes, sir.
So I just want to ask that this petition to the United Nations has an expiry date, and how long do you think that it will take, like get reference to the Brazil president, right? So how long do you think it will take for the justice to review if everything goes well?
Okay. In taking Lula as an example, in Lula there were 2 or 3 sets of hearing by the working group. Hearing meaning they don't hear people, but they hear the communication. They have made an interim opinion, not the final opinion. They made an interim opinion asking the Brazilian government to release Lula immediately so that he can participate in the election. Sending Lula to the prison by the court in Brazil, listen carefully, sound very familiar, was to deprive him from competing in the election. That's why they rush and they bundle him up into prison. So the United Nations body said, we give interim relief, get him out, this is our advice, so that he can participate in the election, so that further human rights breaches will not occur. Then they came up with the final opinion. In Lula, of course, because it was very convoluted, yeah, Lula involved an allegation of corruption, famously known as the car wash scandal. Kita sini kita panggil SRC 1MDB, sana car wash scandal. But it's not car wash kind of minuscule amount of money. Is also in billion. Yeah, but as you know, today Lula is the president of Brazil. So it was quite effective in that sense. Yes.
Do you think by sending the petition to the Commission, you give any chance to be released or retire?
Well, it gave him 2 chances instead of just 1. So one is with the federal court, the other is with the United Nations. Yes, sir.
Are we going to be sanctioned if the nation decided not to abide by this decision by UNWTAD?
Yes.
Are we going to be sanctioned by the UN?
Most definitely. The sanction can happen in various formats. It can be a silent sanction, because if you do not abide by the United Nations advice, as I've said, why be the member at all? Why do you want to remain to be a member of the United Nations? Because we have subscribed to a prescribed mode of standard of human rights. You see, you and I should be interested in this, because one day you or I, chances are it's me, not you, will get into similar trouble. So if you don't have an avenue to complain about your own government, you're a dead duck. Okay?
Dr. Chu,
Yes.
since you have mentioned in the press statement the name of the current Prime Minister, would you be sending this petition to lobby Dr. Sri Anwar, or has he been mentioned in that petition that you're giving to the working committee?
Okay. Although nobody have ever sent to the government a copy, I suspect that Sri Anwar Ibrahim, when he sent a kind of similar communication, he may not have sent it to the government, because the United Nations will give to the government. But today, as we filed it, we also sent to the government of Malaysia. To whom?
The International Division of the Attorney
Yeah,
General's Chambers.
the International Division of the Attorney General's Chambers has received it today. That is purely out of courtesy, not compulsory.
Would you be giving a copy to Dr. Sri Anwar personally?
Well, that is something interesting. I certainly would. There is no downside to it. After all, he endorses this body very strongly because there was some opinion expressed with regards to how he was treated in the prison when he was kept in the prison over the 2 occasions. So he found that there is credibility in this body. So certainly it is a good point that you have raised, that we may just give it to him in the form of a separate petition enclosing this. Royal pardon, we have given the royal pardon papers as early as soon as he went in, within 3 weeks, I think, we have put in the royal pardon. I do not know the progress of the royal pardon because it is all hush-hush. As you know, things like this, they do not move openly, right? But I must stress that the royal pardon should have moved so fast because our complaint is the first time in the history of Malaysia, maybe one of the very, very rare occasions in the world. We say, you please pardon my client not because he is now begging for mercy, because he has committed the crime. No, we are saying he has not committed the crime, but you pardon him because your own judiciary has not granted him a fair trial. So you better pardon him. Because if you don't give him, if a former Prime Minister never got a fair trial, what are your chances? Just think about it. A former Prime Minister never got a fair trial. What if you get into trouble? What are your chances? Yes.
Yes. Looking at the requirements for this particular committee is very high. The requirements for it to do something is quite high. You must suggest there's a breach of natural justice in this situation.
Correct.
Reading your statement says that the court did not allow this defense to even make submissions, which I have covered the thing from end to end.
Right.
That was not the case.
What do you mean by that?
Justice Manu has asked repeatedly for lawyer to submit submissions.
Right.
He wished not to do so.
Correct.
Even asked whether to use your submissions.
Right.
And he denied to do so.
Correct.
So the court did allow him to make submissions.
Correct.
He did not.
Can I ask you to demonstrate a simple question? Assuming you were a single page because you have just been appointed. I am Tunku Maimun. Ask you, submit. You cannot submit because you're not prepared. Is that a true giving of a chance for you to submit? Or is that illusory? Is that a pretended right given to you? When I give you the right, that right must be able to be used by you, not in a pretended way. Must be realistic. All right? That's what we're saying here. Therefore, there was a total breach of human right and a breach of natural justice. And clearly, you were there. Was there any argument on the sentencing? Zero. It's a fundamental right.
But why you only raise it now, like 4 or 5 months after he's gone in, to raise it, how come you deny the right to submit on the sentence? Why now?
What do you think the review was about?
To deny the right to submit.
The review is all about that as well.
I'm not concerned from Chief Justice that, this will set a precedent because others will keep changing, last minute changing their lawyers just to buy more time, that's why.
But you forgot, I've just said, with the exception of you, nobody said this was a ploy to delay. Nobody said in this case. And what more, the prosecution said, we have no objection to the adjournment. So what is it, the problem with the court to grant 4 months or 3 months or even 2 months adjournment. What is it that is biting the court? That they cannot give it. In this case, they cannot give it. Other cases we can give. Why? Think about it. I don't want to say it because I'm bordering on contempt, but think about it. Why the court didn't want to give? I think you have the answer.
So,
Yes.
For the January 19 review hearing, is Dr. Sri Najib going to go ahead with it, or will you apply for postponement because you just filed this today?
No, this has nothing to do with the 19.
So you go ahead with the January 19.
As far as we are concerned, we can go ahead, but we have been told that there is a problem with the assembling of quorum because there's not enough judges. So 19 can go on, 20 and 26 cannot go on. As you know, this is an argument that will take more than 3 days. But we will see. But to answer your question, we are ready to go on the 19th.
Are there any health reasons on Dr. Sri Najib that has been included in the petition?
No health reason included because whatever health reason that he had, although it was very cumbersome and delayed, he finally managed to see some of the doctors. Yeah, there was one episode that was life-threatening. I think you know about it, where his hemoglobin level went down to 7 point something when you should have 17 on the average. 7, you could just die. But he was lucky, so they put in, they transfused blood from some donors. I think about 2-3 pints of blood in order to save him. That happened. Yeah. That was, I must correct, before he went into the prison. Meaning, even while in the best of care in his home, this was a slip. No, he didn't realize why he was tired. Because nowadays, sorry, I have to say this. Nowadays, our toilets are modern. You go and sit in the toilet, you do your job, you don't even see what you have done, and you walk away. If you see what you have done is totally black, chances are it's blood. Most of us do not even know. So he lost a lot of blood through the various issues that he had in the esophagus, in the stomach. He had a lot of ulcer.
And this United Nations working group refused to accept or...
No, they can't.
Are there conditions that you must meet before they hear it, like before hearing?
Yeah, of course. If they see your communication is rubbish, of course they will answer to you that we have seen. They will not say it's rubbish. We have seen, and we do not think there is any transgression. They will express an opinion. They are very, very independent. All right, they're extremely independent body. So far, there has never been any allegation against them. Just like we used to have the Privy Council, there was no allegations of biasness, nothing. I think the Privy Council has never had an occasion where recusal was made because they were upright. And even in the House of Lords, only in the case of Pinochet number 2, the question of recusal was raised. But the judge, Justice Hoffman, like a typical English gentleman, he disclosed everything that he was involved in with Amnesty International. And that's how the second quorum was able to say he ought to have disqualified himself.
So are there conditions that you have to meet before the UN working group decides to hear your...
Yes, we feel we have met more than the condition imposed.
How is the health of Dr. Sri Najib at this point of time?
At this point, he had, apart from that stomach problem, he has been put on diet that are lesser in oil and things like that, so that there is no bleeding in his of his ulcer. His ulcer still is there. Once you have an ulcer, you'll always have an ulcer. But he's being monitored. His blood pressure is being monitored constantly. He has got issues with his, I'm not sure whether it is right or left knee. You remember he had an operation done where certain part of his muscles were removed because there was too much pain, which means even before he went to the prison, he can't play football, for instance, because the knee can rotate. The axis muscle, one of them were removed. So he has got excruciating pain, which requires him to go for physiotherapy.
What would stop the working group from saying that the working group should exhaust its options at the review stage first?
Okay. As you know, review is not a process that is as of right. Your right is appeal. We have exhausted appeal. Same thing with Lula and all that. They've exhausted their right. So exhaustion of domestic remedies has been done. This is a mere review vis-a-vis our letter to the working group.
Who is the jurist on the Malaysian jurist on the board?
Oh, you want to know? I don't know. Well, you can actually find out. You can actually check on the website. I don't know whether she wants me to announce it. I do not know her, to be very honest. She's an Indian lady from Malaysia. Okay, supposed to be extremely eminent, and there are people from New Zealand, highly qualified. People from Ukraine. There's one lady from Ukraine. Ecuador is the chairman, is a lady. Then there's two others.
About this UN working group, right? What is their jurisdiction over Malaysian courts? They already have the federal court for the jurisdiction of Malaysian government.
It's advisory, but because you're a member of the United Nations, you abide by the advice of a United Nations body. You remember when I was sitting representing Malaysia in ASEA. ASEA is ASEAN Intergovernmental Commission of Human Rights. We had a visit by the High Commissioner of Human Rights of United Nations. She came in. It was a lady from Sri Lanka. She was a chairman, and she came in and gave advisory opinion to this group of us who constitute ASEAN members, and we abided by her opinion.
Sorry, Tan Sri Su, on January 19th, you are appearing, the review is on, yeah, the 7-member panel is on.
I didn't say 7 member. I requested for 7, minimum 5, but we now learn that there's only 6 members balance that have not heard the first time. So only 6 members are qualified. So chances are it could be 5. We are all right with 5, provided they are from the federal court, permanent judges of the federal court, and not being taken from the Court of Appeal to sit on an ad hoc basis. Yeah. That I will object.
And the submission filed, have you filed these submissions for?
We have asked for extension until Monday.
Until Monday.
Yeah, until this Monday, simply because yesterday and day before yesterday, we were busy filing 2 election petitions. Because the last day were yesterday and day before. Yeah.
Has the federal court allowed the extension of the filing of submissions until next Monday for the SRC case?
They haven't replied. But they haven't replied. Okay, although we have written in, when was that? Yes. Monday. Yeah. Earlier, 2 days ago, we have written in. But normally this is not an issue. If you don't extend, and then you say we don't want to accept, it will be another breach of human rights. Okay? So this is not an issue at all. No. If we give on Monday is what day? Monday is the 9th. They got 10 days to read. Right? They got 10 days to read. Going by the judgment in the Datuk Sri Najib's case, the CJ said 10 days is more than enough to read. All right? We have got tea and some drinks. Please enjoy yourself. Oh, tunjuk lagi. Okay. Dekat juga. All right. Okay. Okay, these are the two. All right. Now I can show you this thing so that you can zoom it. You can see the title.
Boleh letak kat sebelah dah ni.
All right. All right. Okay. Now the second matter, short. Yeah. I take 30 seconds to tell you. This morning we were pleasantly surprised because Datuk Seri Najib was supposed to give evidence. We have provided the written statement of the witness of Datuk Seri Najib yesterday to the prosecution. And today the prosecution announced that they were exercising under Section 254 to offer no further evidence. I suspect the statement by Datuk Seri Najib was very clear that Tan Sri Syahril was not guilty at all because he spent his own money in Johor Bahru for political and welfare purposes. And according to Datuk Seri Najib in his statement, that Tan Sri Syahril is one of the most honest person he has ever come across. He has no doubt if Tan Sri Syahril required the replacement of that money, he had no doubt that it was true, and that's why he gave it to me. Okay? Thank you very much. The what? Is a witness statement. A witness statement that has been given to the prosecution. So it is on record. All right? It's okay?
Yeah.
No. I wish I can do that because they will scream. Okay? But you will get it soon. You'll get it soon because the government will say, we got it. Once everybody has got it, we get it. All you have to do is to give me a call. Yeah? You got my number? That's why I told your familiar. This is Latifah Koya's sister. Yeah.
I heard that twice today.
Really?
Yeah,
That's not good or good?
I don't know. I don't put it on record.
Yes.
Mungkin saya cakap saya salah faham. So apa yang untuk kita tu Siano, investigation punya argument untuk kita tu Siano dan rejected. Aku saja yang doesn't 2015.
Yes.
Jadi
Hello， 荧幕前的观众朋友，大家下午好。现在呢是下午的3点57分，已经接近4点了。那么我现在的所在位置呢是在纳吉的代表律师沙菲宜的办公室的里头。那么他在刚刚的3点05分左右呢就召开了新闻发布会。那么今天呢最主要是要来跟进关于纳吉的这个 SRC 案件的进展，因为相信荧幕前的观众朋友都知道嘛，在这个案件呢，其实已经是审了4年，在去年8月中的时候就迎来了大结局。那么涉案的这个纳吉呢，他就被定罪入狱12年，还有罚款2亿1000万令吉的。那么从8月到现在呢，他已经是长达4个月的服刑。那么刚刚呢，他就有提到，就是代表律师沙菲宜还有提到说，现在纳吉他是透过他们的这个律师团队 就是入禀这个请愿书给联合国。那么这个联合国的这个是叫做 UNWGAD， 就是联合国任意居留问题工作小组。OK， 因为其实最主要的就是想要因为他们在从这个案件呢，就是已经定罪到现在，他们都一再强调这个纳吉没有被公平的这个审讯。那么还有提到他们是要让这个联合国任意居留问题工作小组呢去做一个裁定哦，就是讲说他们在去年的8月23号的这一个判决呢，对纳吉来讲是有缺陷。那么是不公正，然后也违反他的这个人权还有联邦宪法的，所以这个是他们今天的这个最新的进展。那么因为我们知道他们这个案件 SRC 这个案件，他们已经是有入禀这个司法检讨，那么要求新的一批的法官检视之前这个联邦法院五司的这个判决，所以呢，这个司法检讨会在今年的1月19号开庭审理。刚刚我们就有问到他，跟他们这一次就是将请愿书提交给这个 UNWGAD 会不会有冲突？他是提到是没有任何冲突的。那么这个就是今天他要跟大家讲的。那么至于其他更详细的这一个完整的报道的话呢，大家可以去等我们今天晚上的这个热报，还有的就是新州的这个完整的报道哦。所以这就是我们今天的这个全文。所以非常感谢大家的这个收看。那么想要知道的话，就敬请留守百格。